more informal when we just do it in chambers, but because of your interest to have it recorded, we'll do it out here for you.
Okay.
And the judge will be out in a minute.
Thank you.
Okay.
Oh, you didn't like my petition?
I liked it, appreciate it.
Oh, you appreciate it.
I understand what you're trying to do. I mean, I appreciate it.
Yeah. I mean, you know, you're doing your job. I understand.
Right,
I mean, I
right.
don't hold it against you.
What?
I don't hold anything against you.
Well, I appreciate that.
I do have a legal opinion here that compels a certain action.
Okay.
Is this actually got something in it?
There should be blood.
Oh, can I have it? Of course. Such a luxury accommodation.
Maybe if you open it, that would be helpful. Here, let me do it.
What's the deal?
She's got it.
Where?
Al, here.
I'm not so smart, I guess.
Al, let me take care of
I
it.
just have to get...
If there is some water in there after you figure out the gadget on top, let me know and I'll take it down.
Support.
I have some in mind, and I'm willing to share.
Oh, yeah, thank you. You're very lucky. Oh, no, we got something figured out. I'm not as bright as I should be.
There you go.
Thank you.
I've been in office for 8 years, so I know how this all works.
So how's things down in the salary division over there?
In the salary division?
Yeah,
Yeah.
things are good? I mean, just out the regular.
In my department,
Yeah.
sure, I guess.
Yeah, everybody's happy and
Yeah.
things are going along just great.
It's going.
I'm glad to hear that. Things aren't going so well on the other side.
I'm sure there could be tons of reroutes this afternoon.
Oh, I can't wait. But yeah, there's supposed to be like really heavy rains.
This weekend's gonna be murder.
So you know it's going to be a mess out there.
No problem, yeah.
Lots of great dispatch stuff.
Oh, yeah. Make sure I tweet this, if you can, tweet as soon as you can, and I'll pull it up.
Yes, right. Bill, anybody can get it.
I love it.
Do you mind if I take a picture of you?
Well, what?
Can I take a picture of you? Just a picture, a still picture.
I prefer you don't.
Oh, okay. Just for my blog.
I know.
Okay.
I know. That's my preference.
Okay.
Avoid.
No, I'm not going to stick it in your face and do it to you if you don't want it. Even though I can't get disciplined anymore. I don't work there anymore.
Yes, that's true.
I'm sure legal's heard of me, too.
But I never forced myself on anybody.
Yeah.
Ever. And neither should you.
I don't.
No.
When drivers start cursing at me and
Well,
threatening
don't
me.
be in their face and you won't have that.
Well, I'm sorry when I take a picture of an old 2500
Well,
overhead
don't
that's
be
broken.
right in front of them like, you know. We've already discussed it.
I know.
They're trying to do a job which is not easy.
I
And
understand
they're
it.
not exactly intelligent people, you know. So they flip out.
Yeah, when I had the same driver threaten me twice, yeah, I know.
Well, unfortunately, he's not
Last-
educated, is he? He doesn't
Last I
understand.
heard, he has a warning now.
Well,
Both
okay,
of those drivers have warnings.
Well, you should know better than to be threatening people. That's
Mhm.
why I defended you.
Oh, I know.
Even what you did, it doesn't deserve them to behave in that.
Yeah.
You know, and I didn't support what you did. I mean,
Right.
chasing them around the bus and stuff.
Well,
Okay.
but I never interfered with. I never blocked that bus
I
from
know you
leaving.
didn't. I saw it.
But hey, that 20 driver who kicked me off, it's now up to 700 views on YouTube.
I saw that one.
Yeah, and 900 on your blog.
Really?
It's viral. No, yeah.
Yeah, you need to get some controversy going.
Oh, I'm sure. Oh.
Well, here we go. Do we have to stand or something?
All right, first now section, the Honorable Jerry B. Hudson presiding.
Good morning.
Good morning.
Good morning.
You may be seated.
Thank you.
All right, this is the time set for an initial case management conference in the case of, how do you pronounce your
Margulies? Al Margulies?
Margulies?
Yes.
Mr. Margulies versus McFarland. And I understand that you're representing yourself. Is that
Well, I haven't had, I wanted to make a motion or ask you if I could have more time to secure my own attorney, and I haven't had time to find an attorney to represent me in this case.
Okay.
Because this was supposed to be a small claim.
Yeah, let's just do one thing at a time. So first, so you are representing yourself.
At the moment,
correct?
because I haven't had time to
Okay.
get myself.
All right. And for the defense?
Yes, Your Honor, Kim Sewell.
All right. And with regard to your request about counsel, so there is no time limit for hiring an attorney. So I haven't put any time limit on you, nor do the court rules, other than, there are things that will happen in terms of deadlines in the case, and the sooner that you hire an attorney, the better off you are, frankly.
Oh.
So the purpose of today was really to get the case started in terms of figuring out what sort of track it's going to take, and I'll explain that to you in a minute, and to assign to you a motions judge who, if there are any motions filed in the case, that judge will hear it. The purpose of that, this is a fairly new process too, by the way, and the thinking behind it is if we assign a motions judge early on, then there will be consistency for the parties because they'll know who it is that's going to hear all motions in the case, and they can deal with that judge and their judicial assistant in terms of scheduling things. And so in your case, I'm going to assign Judge Fuchs as your motions judge.
Write that
Do
down.
either of you have any objection to Judge Fuchs serving in that capacity?
I don't, Your Honor.
I don't have the slightest idea who he is, so I guess not.
Okay, well, it's a she.
Or she, yeah.
Yeah. Judge Alicia Fuchs. Are there any motions currently pending?
Your Honor, we have filed a motion to dismiss.
Okay, all right. So what I would ask is that you not contact her chambers for a couple of days. The reason for that is if you walk down the hall right now to try to set something up with them, they'll say, we don't know anything about this case.
Wait for it to kick in.
Yeah, wait
order. Okay.
until I communicate with their office so that they know that they've been assigned as the motions judge.
Okay.
Otherwise, they'll have no idea what case you're talking about. So if you just give a couple days for that to happen, that'd be great. I'll send that communication today, but that'll give them a couple days to get the heads up. So with regard to the first thing that I mentioned, for your benefit, Mr. Margulies, there are a number of different tracks that a case can take in civil litigation these days. The normal one we refer to now as a regular course case. The others are, if the case is below $50,000 in terms of what the plaintiff's asking for, then it's subject to mandatory arbitration, and there's a whole set of rules that deal with arbitration. That's one of the other tracks. Another one is one that was created about a year ago to try to deal with cases that are smaller, to have them handled on a more expedited basis with less discovery, and that's called the expedited civil jury track. That one's consensual, meaning that both parties have to agree to be put in that track, because I believe there's a 6-person jury, if I remember right, as opposed to a 12-person jury, and the trial has to take place within a shorter period of time. I think there's more limited discovery. So that's something that you'd have to agree on if you wanted to do that. A 4th track, so that's regular course, arbitration, expedited civil jury trial. A 4th track would be a complex case designation. And for that to occur, you'd have to I'd set a conference with you with the presiding judge, and the presiding judge decides whether a case is complex enough to merit that designation. So those are the different possibilities. Either of you have any sense already for which category this case falls into?
Go ahead.
Oh, Your Honor, I would say it probably falls in the regular course mandatory arbitration track.
Oh, so those are two things you just said, regular course and mandatory
Well,
arbitration.
I'm just reading, it's regular course with mandatory arbitration.
Okay, all right, but not regular, okay.
In other words, I
So
think...
effectively, you think it should go to mandatory arbitration first?
I
Object.
believe, well, I believe the complaint is under 50,000.
Yes, but he said I could have an expedited civil.
That's if the two of you agree on that.
Oh.
That's a consensual program.
I see.
Yeah.
So
And it doesn't sound like she's going to agree to that.
So can I object to her motion?
Well, you can, and you've made a record of that now, but what's your basis for it? If the amount's less than
I think
50,000?
my basis is I think a citizen jury is going to give me a better hearing than a...
Well, just so that you know, the mandatory arbitration program is set up so that ultimately if you want to have a jury trial, you can.
Oh.
What happens is you go through arbitration first.
Mhm.
If you like the result in arbitration, then obviously you're not going to ask for a jury trial. But if you don't, then you have what's called an appeal with a trial de novo, a Latin term for meaning that you have a trial.
Oh, okay.
And
get you.
and either side can appeal from the arbitrator's decision and ask for a trial de novo. But you'll need to familiarize yourself with those rules. Just to be clear, Mr. Margulis, since you're representing yourself, when I became a judge, I gave up the right to give legal advice, okay? I'm not a practicing lawyer anymore. So
Yeah.
I'm explaining to you the process in general terms, but I can't take responsibility for giving you legal advice about how to do things.
Yes. thank
So
you.
you'll want to familiarize yourself with those rules. But I think given that the amount at issue in the case is less than $50,000, this is subject to the mandatory arbitration program. In terms of what you'll get from me after this hearing, I'll send an email to both parties. Assuming do you have an email address
Yes.
that I can send stuff to?
Yeah.
Your Honor, I don't know if that takes us out of, I do have a pending motion to dismiss I would like heard by a judge before we...
That's what. So what happens is I'll assign Judge Fuchs as the motions judge.
Okay.
She'll hear that motion. If the case gets dismissed, then obviously it won't go to mandatory
Okay.
arbitration. If she denies your motion,
Sure.
then it will go to mandatory arbitration.
Do
Alright, thank you.
I get to know what your motion is? Or you
Yes,
get to tell
I
me?
served you a copy, but I'll be happy to give you another one.
Oh, you gave me a copy of why you're going to dismiss my motion?
Yes,
Oh.
but I'll find more than...
I don't remember getting that, but...
Okay. All right. Well, if you provide him
I
with
will.
another copy, that would
Sure.
be great. So Judge Fuchs will be assigned as your motions judge. And I will indicate that this is subject to mandatory arbitration. And what that means is if the motion to dismiss isn't granted and this proceeds through that program, you'll need to have an arbitration hearing within 180 days. You'll receive notice from the court with a list of potential arbitrators to choose from. And as I indicated, Mr. Margulis, in terms of hiring an attorney, obviously the sooner that you get one on board, the better. But in the meantime, you should familiarize yourself with the rules regarding mandatory arbitration.
Okay.
And what I'll do is I'll follow up with an order that indicates that I've done that I've assigned Judge Fuchs, and that this is going to mandatory arbitration. But I need to have, so Ms. Toole, is your Oregon State Bar email address one that you'll receive stuff at? Or?
It is, Your Honor.
Okay. So Mr. Margulis, do you have an email address?
Yes, my last name and the letter A at the end
Okay.
at gmail.com.
All right. And is there a period between your last name and the A?
No, it's just all one.
Okay. And the way I have your last name spelled is Margulies?
Correct.
Okay.
Thank you, sir.
All right. So Margulis A
At
at
G-
gmail.com. Got it. Okay. All right, great. That was all that I had today. Is there anything else that either of you needed to raise at this time?
No, Your Honor.
Nope.
Okay. All right, we're in recess. Thank you.
Thank you. Okay.
Order that I believe you're challenging, the Herb decision, right?
Yes.
Yeah.
I guess.
That is in an appeal mode right now.
Yeah, all right.
And because of that, there's a legal term that says it's not appropriate for this court. And so that's all I'm
They
saying.
take precedence, what you're saying? That court has to rule
Yes,
on.
that court has to rule on it first. So it's really just a truly legal argument, but that's really why my motion to dismiss
Yeah.
is filed.
You're pretty sure it's going to be granted.
Well, I'm pretty sure, again, my feeling is they're going to wait till Herb decides the issue. And if Herb hasn't decided the issue, this court doesn't have jurisdiction until it's final.
I see.
And so it's been appealed, there's a hearing date. Are you aware of the hearing date?
No.
Let's see, I believe it's set for, where are you?
This is for the,
Yeah, the Herb decision. I don't have my exhibit. I believe it's set for October 16th. But I'm more than happy to get you that hearing date.
okay, well, that's fine. I'm sure.
And if you want a copy of this, I can email, you want me to email it to you?
Could you please?
Yeah, is that the, I don't know, I wrote it down a bunch
Yeah,
of times.
it's my
but
last name.
Is it marguliese@gmail.com? Okay.
All right, thanks a lot.
You're welcome.
Appreciate it.